Hello, I am Surya Subedi. I am Professor of International Law and the author of the study guide on international economic law. Today, I will talk about section D of this course, which deals with international law of trade. When I say international law of trade, in this context, I mean public international law of trade rather than private international law of trade. Public international law of trade is basically based around the WTO law. World Trade Organization came into existence in 1994. There were about 26 different trade agreements concluded at the conclusion of the Uruguay round of negotiations. There were various rounds of negotiations, but the Uruguay round was the most productive one, which resulted in these 26 or so trade agreements, including the one known as the Marrakesh Agreement establishing the World Trade Organization itself. Therefore, the course provides with an overview, historical development of international law of trade, an analysis of the WTO agreements, an analysis of the WTO as an institution itself. What are its powers, functions, what it is mandated to do, what it has been doing to advance the international trade agenda. To begin with, there is a section on the notion of a free trade. Why regulation is needed in this area, and what has been the historical background to the establishment of the WTO. The predecessor of the WTO was GATT, some sort of a provisional mechanism which lasted for a long time. General Agreement on Trade and Tariffs, that is the main agreement. In an amended form, that agreement is still valid. That is one of the core agreements of the WTO. There are a number of other supplementary and subsidiary agreements, but with regard to the trade in goods, GATT is the main agreement. In its revised form is still in existence and constitutes one of the core WTO instruments. Then I go on to examine in greater detail the liberalization of trade in textiles and clothing, liberalization of trade in agriculture, what are the positions of different groups of states, what was the negotiating background during the Uruguay round of negotiations, why these trade issues were introduced into the Uruguay round of negotiations, what has been the outcome, and how the disputes between states with regard to the greater liberalization of trade in agriculture. For instance, the agreement on agriculture is basically a framework agreement in my opinion. It lays down conditions under which further liberalization could be achieved. So, that the process of negotiations, what are the positions of different groups of states, and then how the WTO is responding to the challenges, and what are the issues that have been difficult to hammer out in the negotiations. Of course, you must be familiar with the current round, which is known as the Doha round. Of course, that remains suspended or stalled, not much progress is made there, but when the Doha round of negotiations began in Qatar in November 2001, there was an ambitious program to further liberalize the trade in agriculture. But the Doha round at the moment is going nowhere, and there is a risk that the round might very well collapse. No state is prepared to accept that eventuality, but at the same time for the last 3-4 years there has been not much progress within the Doha round of negotiations. The negotiations are stuck on a number of issues, and one of them is the further liberalization of trade in agriculture. Then I go on to examine the WTO as an institutions, various councils within it, trade, TRIPS and services council. What role do these councils have to play, and how the WTO is responding to issues such as the interface between environmental protection and the expansion of international trade. Many people argue that the biggest contributing factor to the degradation of the environment is the liberalization of trade. more and more goods are produced to cater for all tastes and needs. Therefore, the liberalization of trade, expansion of international trade is one of the major contributors to the degradation of the environment. So, how the WTO is responding to these concerns, that is for example, an area which I have looked at in the study guide. The whole idea is to of this section is to introduce you to the world of international trade based on the WTO agreements, the origin of them, the current law, the application of it, and focusing on the WTO dispute settlement body. That is the main mechanism which has been regarded as a successful mechanism. Nearly 350 cases have now been referred to the WTO dispute settlement body. It is regarded as one of the success stories. Why it is so? What is the jurisprudence coming out of this body? What is the mechanism, how it works? It is supposed to be a speedy mechanism to resolve trade disputes in an efficient and speedy manner. The strict time frame that the WTO dispute settlement body has to apply to resolve disputes has been regarded as a good model for other international dispute settlement mechanisms. Therefore, since this is a law course, international trade law course, the focus is also very much on the jurisprudence of the WTO dispute settlement body and the recent trends in both law and jurisprudence, and how the WTO is likely to go on responding to the current challenges brought about by globalization. That is the focus of this section D of the course on international economic law. Thank you.